Yes, we're okay. Welcome everybody. We're proud to host another edition of the Arbitration in Court session, and along with Andrea, I want
Tonico is falling. Caiu. Okay, Tonico is facing an internet problem.
Either that or you've just made a coup d'etat, Andrea, and assumed Tonico's position.
Okay, guys, let me introduce our group. Our group focuses on stimulating knowledge about domestic and international arbitration, but also promoting a dialogue between the judiciary and the arbitral community in order to strengthen both jurisdictions. We have a pleasure today to have fellows from US, especially professor, I can say faculty, Steven Sertiman. Steve was my professor in New York. And also I have special feelings regarding this meet because Steve is a faculty that giving, how can I say, encourage me to move forward to get that certification. That's why I have, I'm delighted to receive you here. Is the way that say publicly thank you for everything, and also give the receive that knowledge regarding international arbitration, especially some issues that we have facing in Brazil regarding grounds to set aside arbitration award, and also issues regarding confidentiality, impartiality, and let's learn a little bit more what happened in US regarding arbitration. So I don't want to lose your time. Thank you, Mauricio, also, and Philippe, both in US, to give us that international perspective. These past few months, we had an international overview from Portugal and also UK. Now we have this great opportunity to receive this overview or legal framework from US. So thank you, guys. You have the floor. Please, Steve.
Well, thank you very much for those very kind words, Andrea. That was really very nice of you. I don't deserve most of it, but I do appreciate it. Thank you. So thank you all for coming today. And I hope that we'll be able to introduce you to the US legal system for those of you who aren't already familiar with it, and then tackle a topic that is always interesting and always controversial, and that is the manifest disregard of the law topic. So in the US, there are federal courts and state courts. Some subject matters must be brought in federal court, and an example of that is copyright cases. Then some subjects may be brought in federal court, and that most commonly has to do with what is known as diversity jurisdiction, a case between two individuals from different states or two companies from different states where the amount of the dispute is in excess of $75,000. But as it turns out, applications to confirm or vacate an arbitral award can be brought in either federal or state court. And sometimes there may be an advantage to one over the other because they have their different procedural rules and they have their different sets of common law. So there's one federal court system in the United States. As you can imagine, there are 50 states. There are not only 50 state court systems, but there's more because there's one for Puerto Rico, there's one for Guam and American Samoa, etc. There may even be more than that. Oh yes, the US Virgin Islands. Depending on what location you're trying to confirm or enforce the award, that's the legal system you'd use. And in the federal system, like in most judicial systems, there is a trial level court. In US federal, there is one intermediate appellate court. And then there's the US Supreme Court. And that's all we have is 3 levels. Some places, some states, for instance, have more than 3 levels, New York being one of them. Each district has the country is divided up into districts, and there are many of them, more than 50, because there are more than one district in many states. New York, for example, has 4 districts. And so each district has its federal court. And then each district falls within the geographical boundaries of an appellate court, which are known as the circuit courts or the circuit courts of appeal. So, for instance, New York is in the 2nd Circuit, and the 2nd Circuit covers the district courts from New York, Connecticut, and Vermont. There are 13 circuit courts of appeal. The final level, again, is the US Supreme Court. But the US Supreme Court takes only 2% of cases that are brought to it. If you're not happy with the decision in the circuit court, you ask the Supreme Court to take your case, and they say yes or no. It's not a matter of right. And they take only 2%. So for all practical purposes, the circuit courts are often the final arbiter of disputes. 11 of the circuit courts are geographically based. And then there are 2 more, one that handles administrative disputes from the federal government primarily, and the other handles things such as patent cases. So New York's 2nd Circuit, as it turns out, is one of the most important circuits, and that's largely because of the great volume of commerce that happens there, and because it is a hub of international arbitration. From the point of view of jurisprudence, its decisions are very well respected. So to tie this all into our topic today, the manifest disregard doctrine as a basis for overturning an arbitral award, for practical purposes, begins with a decision of the 2nd Circuit in a case called Wilco versus Swan. And if you really want more information about Wilco versus Swan, you can Google it. It has its own Wikipedia entry. So now I'm going to turn it over to Felipe, who's going to talk a bit about common law systems.
Sorry,
Of course.
Felipe, just to clarify or to add some comments on the circuits in the United States, as Steve has mentioned, the most well-known circuit is the 2nd Circuit, because it is where New York is located and where international trade is located. The 5th Circuit is where Texas, Louisiana, and Mississippi are located. Texas, so for example, for those who deal with oil and gas, and when there is no arbitration, or even when there is an arbitration and issues for motion to confirm or to vacate, so 5th Circuit in this subject matter has, because of Texas, for obvious reasons, is this circuit to look at. Second circuit is where Illinois is located. So Illinois is based off Chicago is based off many trade on commodities. So issues regarding commodities, the Second Circuit is the circuit to look at.
You mean the
Ninth
seventh, right?
Seven, sorry.
Seventh, yes.
Yes, sorry, Seventh Circuit by Chicago. Yes, Illinois. Yes, I think I misspoken Second Circuit, right? Okay, sorry. Then Ninth Circuit is where California is located, among other states. And so when we have IP issues, normally Ninth Circuit is a circuit to look at. And 11th Circuit is where Florida is located. So this is very important for Brazilians. This is all I'm going to say about the 11th Circuit.
I was going to say this: if you're looking for Latin America, then the 11th Circuit is where you're going to find a lot of decisions. First, I'd like to thank Tonico and Andrea for setting this up and giving me the opportunity to join these two great guys, Steve and Mauricio. Also like to thank Steven for taking the hold of structuring our presentation. And for me, I'm going to start, I would say, still on the Judiciary Organization of the U.S. This is something that for us it's quite a bit different. The fact that we have so many states and jurisdictions and districts. And when you go to state courts, you have even more of some catchy stuff, like in Florida, for example, the trial court is the circuit court, and then the appellate court is the district court. So it's the other way around from the federal court. So, you know, sometimes we're looking at district and we're thinking trial level on the federal, and then this is appellate level on in Florida. So we have this kinds of difference between the legal organization, the Judiciary Organization. So the topic I'm going to touch on now is relating to common law legal system, because this is also a big departure from what we're used to in Brazil. And the US, as most of you know, is a common law country. It derived its common law initially from England. The colonies adopted some kind of English common law from the start, and then throughout the time, they developed their own body of common law. So in common law, different from civil law countries, from Brazil, what we're used to, a big part of the law is not codified. It's not legislated. It doesn't come from statutes as we're used to, but it comes from judicial decisions, right? So the way the courts decide cases, there's a doctrine of stare decisis, so stand by what was decided. So once a case is decided on a way, this creates what we call a precedent, right? And this precedent will be binding on lower courts inside the same jurisdiction. And then again, a precedent from the Fifth Circuit in Texas is not binding on a district court in Florida, for example. So we may use that as a persuasive argument, but it's not binding, whereas a precedent from the 11th Circuit is binding on a district court in Florida, as it's going to be in Georgia and in Alabama, which are also under the same 11th Circuit. So the precedents that courts establish, they carry the force of law where there are no statutes. So common law starts where statutory law ends. So there's a lot of rules that are produced by the legislatures, which are statutes, and they have precedence over common law. It is also normal that legislatures will legislate on common law rules that are already defined by courts, sometimes to give it a little bit more of a permanence, sometimes to modify it or even to change what the courts have been decided. So the legislature has this power, obviously, to create law, and this would in turn affect common law and common law rules. What I think it's important and that we're going to touch on, Steve mentioned the Wilco case, and we're going to talk a little bit more about the Wilco case. And there is something that for me personally, I think it's important that we understand when we talk about precedents in jurisprudence, because especially in Brazil, when we look for jurisprudence, we're basically looking for any sentence in a specific decision that we can use on our advantage, right, to support our argument. And here, it's very important that we understand that the precedents here, there's a difference in the opinion between the holding of the opinion and what is called dicta. So what creates the precedents are the holdings. So the holding is a court's determination of a matter of law that is pivotal to a decision. So it's central to the question that's being asked, and the court's holding is normally something quite short and specific to the point. But the opinion comes with a lot of reasoning, and that's called dicta. So the dicta are comments or suggestions or observations that are made by a judge that are not necessarily necessary to resolve the case, and thus it's not legally binding. It's not considered a precedent, right? But it can also be used as some kind of persuasive argument or authority. And this is important as we'll talk about the Wilco case, and we'll see that the actual holding of the case has nothing to do with the big mess it produced under the idea of manifest disregard of the law. So if I can now turn over to Mauricio to address the next topic.
Okay. I don't know if Steve, you want to.
Or is it Steve? I'm sorry.
No,
and if anybody wants to.
No, I just, first of all, I would like to echo Steve's and Felipe's words in thanking Andrea and Tonico for inviting me for this discussion about arbitration and U.S. courts. I shall disclose that Steve kindly created a sort of a roadmap for us to discuss. So thank you very much, Steve. And I add some topics or subtopics, and I'm going to address some of them right now. And one of them is the relationship between the arbitration and the courts. But before doing so, let me just make a short comment on what Felipe has mentioned about the common law legal system and the source of law, the uncodified source of law. And this is based on my experience. It is, as everybody knows here, it's quite normal to see or to come across arbitration clauses where we see all disputes, controversies that arises out of or in connection with this contract, this agreement will be definitely solved by arbitration. And then there are some other inputs in that clause. And one of the inputs is Brazilian law will govern the substantive matter, or the proper law of the contract is going to be Brazilian law. But there is no such a thing of US law or the American law vis-a-vis Brazilian law, French law, Italian law, because here we have Florida law, New York law, Texas law, California law. So each state has its own body of law. There are, of course, federal laws, and Steve has mentioned at the beginning, especially in the IP, etc. But I just want to clarify, because I've seen this in practice, American law. So what exactly are we talking about?
And if I may add to that, that's a really great point. And in fact, the federal courts sitting in a district, let's say New York, will apply typically, unless there's a contract agreement otherwise, or in all non-contract cases, they will apply New York state law, even though they are a federal court, because they sit in New York state. And occasionally there's something that they cannot determine the law in New York. They have an issue and it's unclear what the law is. And there's actually a process for them to request the highest court of New York state to inform the district court what the law is.
Yes, yes,
So
absolutely.
that makes it very interesting.
There you go. Excellent, Steve. And also, and this is also something that I faced, or at least I heard before, some colleagues, or in Brazil, especially in Brazil, asking me, and this goes to Felipe's point, asking me, they have, for example, an issue regarding a distributorship agreement, an arbitration where the subject matter goes to the distributorship agreement, and Florida law or New York law applies. And they asked me, so to provide them with the statute regarding distributorship agreement or agency agreement in a mindset of Brazilian perspective. So because we do have a law regarding this legal relationship, so please provide me that counterpart from Florida, from New York, from Texas.
Yeah.
And
There might be agency law by statute, but there isn't distributorship agreement law.
There we go. There we go. Yeah.
Right.
So this,
And
so
it's
this,
sorry, Mauricio. I was just gonna say, it's funny when we have clients from Brazil and that they ask what the law is, and you say, I have to research what the law is, and it's like, but why? You're supposed to know the law, aren't you a lawyer? But the law changes. It might change every day, so we always have to research and find out exactly what, if it's a precedent, if it's still good law or not. So this is something that's very different from what we're used to in Brazil.
there we go. Yes. Well, that's where LexisNexis and Westlaw, etc., they play a very important role.
So now you know why there are so many lawyers in the United States.
So going to the point of the relationship between the arbitration and the courts, let me share with you some scenarios. And then we go to the specific scenario of the set aside or vacate the award. Scenario number one, an agreement contains an arbitration clause, and yet one party files a lawsuit. What are the options? The option is to file a motion to compel arbitration or motion to stay legal proceedings. So we don't have in Brazil this motion to compel. So here you can file a motion to compel, motion to stay in lieu of the answer. So we don't need to file an answer. We don't need to file a contestação, an answer. We can file a motion to stay. If this is denied, then you have the opportunity to file an answer. So you have these options under the FAA, and we are going to talk a little bit more about the FAA in a moment. Scenario number two, an arbitration is on its way, and one party starts lawsuit in another jurisdiction. What are the options? The option is to file an anti-suit injunction in order to prevent this arbitration from going forward. That is one option. I'm not saying that's the right option, but that is one option. Third scenario, a party, normally the respondent to an arbitration, asks a court of the place of arbitration to stop an ongoing arbitration. That is an anti-arbitration injunction. And we know there is also fights between courts in different jurisdictions of this anti-arbitration injunctions. Fourth scenario, the court's assistance in the US in the taking of evidence in aid of a foreign arbitral or foreign tribunal, I should say. And this is something that is what we call the 28 U.S. Judicial Code, Section 1782. 1782, basically, it is just one, it is a one U.S. remedy, one U.S. tool in aid of foreign tribunal, so that the party, a foreign party, can seek assistance from the U.S. courts in order to have testimony, to have documents in aid of something that's happening in a foreign tribunal. This is a very interesting tool for foreigners. The question then is whether foreign tribunal includes foreign arbitral tribunal or not. There is a split of authorities in the circuits in the United States, and recently the United States Supreme Court has granted certiorari to decide whether foreign tribunal is indeed arbitral tribunal or not. But for time being, this is something that can be used. The way it is used, or the way it can be used, it is not as simple as it looks, because if the tribunal is already in motion, so if one party goes to the court of one of the judicial courts of one of the parties seeking evidence, so this may create some issues before the arbitral tribunal. It happens prior to the composition of the tribunal more often. Fifth scenario, a party asks a court to issue an interim measure of protection. So we can see in some arbitral institution rules, the emergency arbitrator tool, but this interim measure is also a court assistance for when there is an arbitration, if that's the case, or prior to the arbitration. Now, sixth scenario, at the conclusion of the arbitration, the prevailing party requests that the court confirm the arbitral award, or the losing party asks a court to vacate the award. So now we are at the end of the game, and one party has won, the other party has lost, and the party who loses the case may try to ask the court to vacate or to set aside the award. Before we go into this detail, there is another one. The seventh scenario is the prevailing party in foreign jurisdiction requests recognition and enforcement of foreign award, which is basically what we know, the New York Convention, etc. Now, coming back to the losing party asking for a court to vacate the award. What are the legal basis for vacatur in the United States? So the legal basis, and I'd like maybe Steve, you can also, and Felipe, of course, can address this issue. I just should say the FAA, which is the Federal Arbitration Act, which has almost 100 years, and it was a 1925 federal law. It addresses those grounds for vacatur in Section 10 of the FAA. Section 10 of Chapter 1, and this I should say for sake of clarity, the FAA today has 3 chapters. Chapter 1, which is the FAA itself as it was originally created. Chapter 2, which implements or implemented New York Convention, and Chapter 3, which implemented New York Convention.
Panama Convention.
Panama Convention, sorry, Panama Convention. I would like to mention, or at least to comment on Panama Convention, because nobody says too many things about Panama Convention, and I have a very interesting experience using Panama Convention that I would like to share with all of you in a moment. But before doing so, why don't we just go to the grounds for vacatur under the Section 10 or under FAA? Steve, can you just tell us a little bit more about those grounds, please?
Sure. Well, so as Mauricio mentioned, the Federal Arbitration Act is the principal federal arbitration law in the United States. It's really primarily a procedural law, but it's the gateway for integrating arbitration into the court system. And why is that important? Primarily because arbitration awards often need to be enforced. And without the power of the state to enforce them by turning them into judgments, an award might be futile. So that was the beauty of the New York Convention. That's the beauty of arbitration acts generally and the FAA as well. So because of the state court system, federal court system thing in the United States, if an arbitration is purely within the borders of one state, that is to say, if the dispute is between parties that are within the same state, then there's a chance that the FAA won't apply. Its coverage is very broad. It might even apply nonetheless, but some arbitrations are purely in one state, and then that state's arbitration law will apply. But for the vast majority of domestic, as well as international, all international arbitrations, the FAA applies. And unlike in England and Wales, where the English Arbitration Act, Section 69, permits an arbitration award to be challenged on the basis of an error of law unless the parties agree otherwise, the FAA does not do that. What the FAA does do is spell out 4 very specific grounds. One is where evidence was procured by corruption, fraud, or undue means. Somebody paid off a witness and you find out about it, then you can challenge the award. And where there was evident partiality or corruption in an arbitrator. So obviously somebody paid off the arbitrator, or the arbitrator really had a bad conflict of interest that he or she did not disclose, that might rise to the level of corruption. Where the arbitrators are guilty of misconduct. And that would be in the event of a major mistake in the conduct of the proceedings, denying somebody a fair opportunity or a reasonable opportunity, whatever the applicable standard is under the governing rules or the seat of the arbitration, denying them that opportunity to present their case. And finally, where the arbitrators exceeded their powers. For instance, the arbitrator award punitive damages, and the arbitration clause specifically says the arbitrator shall not have the power to award punitive damages. One thing that I do want to mention also is, where do you seek to vacate an award? I think for our purposes, we're talking about international arbitration awards. And it's important to recognize that an international arbitration award can only be vacated in the seat. Now, there are rare instances of a court that is not the seat purporting to vacate an award. What they're really doing is they're saying we won't confirm it and we won't enforce it, but they don't really have the power to vacate it. The winning party could take that award to another jurisdiction, and it is not a vacated award, and that other jurisdiction might decide to enforce it. So an award is vacated in the seat of the arbitration, in international arbitration. Should I continue, Mauricio, or would you like to take over, Felipe?
I just want to to emphasize this notion of the power of the court located in the seat or the place of arbitration, as we call primary jurisdiction, as opposed to secondary jurisdiction, where is the country or the jurisdiction where the party seeks to have the award being recognized and enforced. So that is the seat of the arbitration, as Steve has properly mentioned. I have some comments on the public policy issue, but before I do so, I just want to ask Felipe if you have any specific comment on this issue.
No, not really. I think what is interesting to Steve's point, and what I see here in the U.S. Is parties that have a pending annulment in the seat of arbitration, and they try to resist enforcement here in the U.S. So one party is trying to annul, the other one is trying to enforce the award in the U.S. And then the resisting party normally brings up the argument that there's a pending annulment on the seat, trying to vacate that award. And here in the U.S., it's interesting to note the application of Article 6 of the New York Convention. As the courts normally, they will only grant a stay of the enforcement, even if there's a pending annulment, if there's suitable security. And normally the courts will understand suitable security as the full face value of the award. Even though there's a system of posting bonds here in the US that I don't think there's something similar to it in Brazil, which makes it a little bit easier for somebody to actually put up a security. This is something that from the research I've done, the courts will normally enforce Article 6 and require the security in order to stay proceedings for enforcement when there's pending annulment in the seat of arbitration.
Okay. Steve?
Okay, well, I'll continue on. So we're talking about grounds for annulment, vacation, set aside, all the same thing. And the New York Convention provides some grounds as well. So it isn't just what's in the FAA. The New York Convention has a public policy ground. It says that under Article 5(2)(b) of the Convention, recognition and enforcement of an arbitral award may be refused by a contracting state if recognition or enforcement of the award would be contrary to the public policy of that country. So you can't ask a country to, you can't expect a country to enforce an award if the enforcement of that award would violate its public policy. This is a very vague term, of course. It leaves open a lot of subjectivity on the part of the judge. And so that's frequently the tactic of last resort, is to attack it on public policy grounds. In the US, international arbitration awards can be denied on that basis, even though the FAA doesn't require it. But it would not apply, the New York Convention would not apply to domestic arbitrations or to international arbitrations seated in the United States, by the way, which also would not be brought under the New York Convention, because the New York Convention is the Convention on Recognition and Enforcement of Foreign Arbitral Awards. So if the seat is in the United States, it's not a foreign award. Okay, and then in the United States, a public policy basis for vacating awards has been adopted by a few states, not many, but again, it would only apply in arbitrations to which the Federal Arbitration Act does not apply. So you might ask yourself, well, can the parties agree to expand the bases for vacating an award? And we're going to get to that very interesting topic in a moment when we discuss the Hall Street case. Another basis for vacating an award found in the New York Convention is under Article 5(2)(a), which says that recognition and enforcement can be denied if the subject matter of the dispute is not capable of settlement by arbitration under the law of the forum country. So an example of that might be an employment contract. If it's an international arbitration award and you're trying to enforce it in Greece and against a Greek company and under Greek law, employment contracts are absolutely not arbitrable. They have to be brought in court. Then the award might be unenforceable there.
On that point, I would note that maybe here in the U.S. is the place where that article has the least application, right? Because U.S. has pretty broad acceptance of matters regarding arbitration. Like in Brazil, we would have the same problem to an extent with employment law and consumer law, but these are all matters that are normally subject to arbitration here in the US. So I would say that 5.2As in United States are really rare to occur. I can't think of anything that might be barred by 5.2A.
That's true. The United States Supreme Court has articulated a very broad support for arbitration as a dispute resolution mechanism. And although there are many states constantly trying to reduce the arbitrability of things, and Congress from time to time talks about, for instance, following Europe's lead and banning pre-dispute arbitration agreements and pre-dispute and consumer arbitration altogether. It's been a very big political football here in the United States. What I always like to say is be careful what you wish for.
Yeah. There is
we don't really have the budget in our court systems to handle all the disputes that they're trying to take back.
Yeah. On that note, there is that bill before Congress, which is a very appealing name, which is Arbitration Fairness Act.
Yes.
Arbitration Fairness Act. So it prevents arbitration within employment and franchising. And the regional bill also contained a very interesting provision, employment, franchising, and anything that contains a difference in bargaining power of the parties.
Mm-hmm.
So it's hard to find a contract where there is no difference bargaining power. So that's where the political debate started.
Maybe Boeing and Rolls-Royce.
Maybe. There we go. On the topic of public policy, as Steve has mentioned, it is a very vague, as we all know, not only in the United States, but in every corner of the world, public policies are very vague. I say it is similar to a mother's heart. So everything fits in. So it is, so you can try to insert within the public policy defense everything you want, but then it's up to the courts of the state to set up the standards where this public policy may play a role. And there is one interesting case in the United States which also comes out from the Second Circuit, which is a Parsons case. Parsons against Société Générale d'Industrie de Papier, which is the RACTA. And there was this allegation of the public policy defense. And the court said something, and I quote, enforcement, invoking the public policy exception is a safety valve to be used in those exceptional circumstances where it would be impossible for a legal system to recognize an award and enforce it without abandoning the very fundamentals on which it's based. Enforcement of foreign arbitral awards may be denied on the basis of public policy only when enforcement would violate the foreign state's most basic notions of morality and justice. That's a very high bar. Mm-hmm. So it's very difficult to prevail on a public policy defense in order to avoid the recognition enforcement of an arbitral award.
Some circuits too, just it's worth noting, like the Ninth Circuit is particularly hostile to arbitration. Particularly California, I should say, where the Ninth Circuit courts primarily sit. And the state of California is regularly adopting one anti-arbitration bill or another. And many of them have gone through the circuit courts and affirmed in the circuit courts, and a couple have been overturned in the Supreme Court. So it's a practitioner's note. Avoid arbitrating in California if you want to have the broadest support. Okay, let's move on to the last category that we see in vacating awards, and that is the judicially created manifest disregard of the law doctrine. That's why we're here today. It's a separate category that arises out of the Wilco case. And it was first articulated in that case, and a number of other circuit courts have, the Second Circuit articulated the Wilco doctrine in dicta, as I think Felipe said, and a number of other circuits have endorsed the idea, and then a few have rejected it. And so, as Mauricio said, as we sit here today, it's on the docket for the US Supreme Court to issue a decision and resolve. This is kind of what happens in our system, resolve the split between the circuits. So when the circuits disagree, hopefully at some point the US Supreme Court takes a case that will resolve that split. The first thing to recognize about manifest disregard of the law is it is about manifest disregard of the law and not about facts. So you can't bring a manifest disregard of the facts claim as a plausible, arguable basis for vacating. Very few cases have succeeded on the basis of manifest disregard of the law. It hangs out there. It's tantalizing to practitioners when they're on the losing side, but it's a very big uphill battle because very few cases, even in the Second Circuit, which articulated it, despite having articulated it, I believe there are two cases where they actually found it. Over many, many years. So this is partly because the courts are very aware of the importance of party autonomy, and they're giving the parties what they bargained for, which is reduced review by the courts of the arbitration award. Also, they consider that the potential for mistakes by an arbitrator is the price the parties paid for agreeing to arbitration. In other words, perhaps they agreed to it because they wanted a faster, quicker, cheaper resolution process. And the trade-off for them was they knew at the time they weren't going to have the same level of review. So that's how they justify not having a manifest disregard of the law level of review of most cases. So it is considered the doctrine of last resort. Who's up next? I think in the interest of time, I have to point out, I think we probably should have a look at the outline and maybe move forward because I'm a little concerned that we're going to run out of time.
Okay. I was going to address a little bit of the Wilco case now, just to give an idea for everybody how this came about. It's funny that the Wilco case is a 1953 case that was heard by the Supreme Court, the U.S. Supreme Court, and it was a securities case. And the case that started and came up with all this idea of manifest disregard of the law had nothing directly to do with enforcement or vacatur of the award. It was actually an investor, Anthony Wilco. He bought stocks from a guy that actually was the primary seller of the stock, so he was involved in the company, and that information was never disclosed. So he bought about $30,000 of stocks back then, which today would amount to about $300,000. And then he had losses, and he sued the defendant under the 1933 Securities Act for fraud for not giving him that information that he was in fact the primary seller. And the case went on because the defendant, instead of presenting his response to the lawsuit, he actually moved to compel arbitration because there was an arbitration agreement in the contract of the securities exchange. And the district court, which is the trial court, the first level, the first instance, denied the defendant's motion, saying that there's an anti-waiver provision on the 1933 Securities Act, and the district court found that that anti-waiver provision took precedence over the FAA, so the arbitration agreement was not enforceable. And then there was an appeal to the Second Circuit, and the Second Circuit actually reversed that decision by split decision, holding that the arbitration clause was in fact enforceable. So then Wilco petitioned to the Supreme Court, asked for certiorari, and it was granted. Like Steve said, the Supreme Court decided to hear the case, and by a split decision as well, it was a 7-2 margin. It found for Wilco, holding that the 1933 Securities Act anti-waiver provision took precedence over the FAA. And then what I said before about holding and dicta, if we look at the holding for this case, it actually says that Federal Arbitration Act does not supersede provisions of Securities Act of 1933, forbidding waiver of right to litigate fraud claims where a contract between broker and investor had binding pre-dispute arbitration clause. So nothing to do with manifest disregard. But in the opinion, in the majority opinion that was written by Justice Reed, in dicta, so in a part that was not actually the precedent-setting part of the decision, Justice Reed mentioned that interpretations of the law by the arbitrators, in contrast to manifest disregard, constitutes ground for reversal. So based on that that sentence, there was this development of an idea of a manifest disregard of the law as being one of the grounds for vacatur. And even though this decision has been criticized, it still haven't been addressed again by the Supreme Court. They had the chance, and I think Mauricio or Stephen are going to address that other case now, but that's how it all started. So a case that had actually nothing to do with enforcement or anything like it.
Yeah, I just want to, before Steve jumps in on other cases, but I normally, in some of the arbitration events or seminars or Congress prior to the COVID, the pandemic, in a pre-pandemic era, I hear, or I used to hear, people say, well, in the United States, there is that ghost, that gremlin, manifest disregard of the law. And it is, but it is not. There is this manifest disregard of the law, it is there, but the applicability or the application of such doctrine is a very heavy burden, very high bar. As Steve has mentioned at the beginning, so it's very rare for a motion to set aside the war based on MDL to prevail. In an international award, more so, it's very difficult for a US judge to reach a conclusion that an arbitral or an arbitral tribunal sitting in a different jurisdiction to find that there was a manifest disregard of the law. So I bringing this up in order to share this comfort, or at least it's a reality that it's very, very difficult and unlikely that manifest disregard of the law defense will prevail. What the party has to show, or at least what the court has to find, is that the law that was allegedly ignored was clear, absolutely clear. That the arbitrators, in fact, had a mistake or made a mistake in the application of the law, and the outcome of the decision itself reached was erroneous. And third, the arbitrator or the arbitral tribunal knew of the existence of the law and its applicability before them and decided to ignore. So it is something that it is not easy, as we have already covered. I don't know, Steve, if you want to address other cases in terms of where are we today, because I want to address some of the flip side of the coin of the MDL.
Well, I was just going to build on what you said and talk about the Hall Street Associates case, which is Hall Street Associates versus Mattel. So here it is many years later, and a case comes to the Supreme Court, which is all about the question of whether the parties in their agreement to arbitrate can expand the bases on which an award arising from their arbitration can be vacated. In other words, the parties say, yeah, we want to arbitrate, but we don't want just the 4 bases in the FAA to be the bases for a vacate. We also want to add, and then they added their own basis, however they phrased it. Well, then that worked its way up to the Supreme Court, and the Supreme Court said, no, the FAA's bases are exclusive. And that was the perfect opportunity for the Supreme Court to put a stake through the heart of manifest disregard. But for whatever reason, they chose not to do it. So the vitality of the manifest disregard doctrine is definitely called into question by Hall Street. It may no longer be good law at all, but the clarity isn't there because the Supreme Court left it hanging out there. So that's the Hall Street case. And so where are we today? People are still bringing proceedings to vacate based on manifest disregard. It's a little bit like Don Quixote, but if the stakes are high enough and the cost relatively small enough, it's a stone that a losing party doesn't want to leave unturned. Post-award litigation still arises seeking vacatur, diluting the benefits of arbitration for the parties. And as recently as September of 2019, there was a case by the name of Weiss versus Sallie Mae. Sallie Mae is a federal mortgage holding agency. It's not an arm of the federal government. It's a corporation that was created by the federal government. It's independent though, and they buy and sell mortgages in order to create a market so that banks that there are other organizations like Sallie Mae, Freddie Mac, and these organizations provide a market for mortgages so that a bank which has written a mortgage to a buyer of a home is not stuck holding that forever. If they want to reduce their level of mortgage portfolio, they can do that by selling off in what they call the secondary market. So Weiss sued Sallie Mae. The Second Circuit again revisited the manifest disregard doctrine, and again it reaffirmed the doctrine still survives, but it reversed the trial court's decision to vacate the award based on manifest disregard. So again, another one didn't make it over the hurdle. In the same case that they said, yes, it's still a good doctrine, they said, but this doesn't meet it, because basically they rarely meet it. Now, Mauricio, I think you raised a really good point during our earlier conversations about the benefit of if there were costs imposed for bringing these proceedings. Why don't you talk a little about that?
Yes. This is interesting because being a manifest disregard of the law, a common law doctrine, something that if you think you cannot prevail in anything that the FAA is set up for you to use in order to vacate an award, and you have no grounds for that, then you have this tendency to use or make use of the manifest disregard of the law defense in order to at least to seek to vacate the award or to postpone the compliance of the award. And so this option or this tool or this strategy of party to what the courts have said as a never say die to an arbitration has some caveats, some issues that counsel or parties must bear in mind. In the case, there was one specific case out from the 11th Circuit back in 2006, which is the Harbor versus Hercules steel case. And this is a case where Harbor was awarded a contract by the US Army, and Harbor subcontract Herbert Steel to construct some facility in Alabama. There was a conflict between Harbor and Herbert Steel. Then the arbitration was started. The arbitrator cited for Herbert Steel. There was motion for clarification, and the motion for clarification for Steel was granted, for Harbor was denied. Then Harbor started its court battles before the court systems, raising the manifest disregard of the law because the arbitrator had clearly erred on using a progress schedule instead of a project schedule in that particular case, and that would lead to a specific law. What is interesting here, and this is very interesting because Harvard has produced other cases or has at least led to other cases, and I'd like to point out some of the excerpts of this case because this is self-explanatory. And I quote, "There is no evidence that the arbitrator decided dispute on the basis of anything other than his best judgment, whether right or wrong, of how the law applies to the facts of the case." So here the court saying, I don't care. This is what Steve has mentioned before. So the parties had agreed to arbitrate the case. So if the arbitrator has made a mistake, that is the problem of the parties by going to arbitration. There is, in short, no evidence that arbitrator manifestly disregard the law. And now the court goes on and saying, the only manifest disregard of the law evident in this case is Harvard's refusal to accept the law of the circuit, which narrowly circumscribes judicial review of arbitration awards. By attacking the arbitration award in this case, Harvard has shown at best an indifference to the law of our circuit governing the subject. That's interesting. In litigating this case without good basis, through the district court and now through this court, because this was a court of appeal, the 11th Circuit, Harvard has deprived Hercules and the judicial system itself of the principal benefits of arbitration. Instead of costing less, the resolution of dispute has cost more. Instead of being decided sooner, it has taken longer than it would have to decide the matter without arbitration. Instead of being decided outside the courts, the dispute has required the time and effort of the district court and this court. And then it goes on saying, when a party who loses an arbitration award assumes a never-say-die attitude and drags the dispute through the court system without an objectively, reasonably believe it will prevail, the promise of arbitration is broken. The more cases there are, like this one, in which the arbitrator is only the first stop along the way, the less arbitration there will be. If arbitration is to be a meaningful alternative to litigation, the parties must be able to trust that the arbitrator's decision will be honored sooner instead of later. Then the court, the 11th Circuit, decided whether it should award sanctions for Harvard to bring this case based on this frivolous case based on manifest disregard of the law. And then it says, a realistic threat of sanctions may discourage baseless litigation over arbitration awards and help fulfill the purposes of the pro-arbitration policy contained in the FAA. We have considered ordering Harvard and its counsel to show cause why sanctions should not be imposed, but have decided against doing so now. And one of the reasons why the court decided not to sanction counsel was that Harvard took its arbitration laws into the district court and then pursued its appeal. It did not have the benefit of the notice and warning this opinion provides. The warning this opinion provides is that in order to further the purpose of the FAA and to protect arbitration as a remedy, we are ready, willing, and able to consider imposing sanctions in appropriate cases. While Harvard and its counsel did not have the benefit of this notice and warning, those who pursue similar litigation position in the future will. So there was no sanctions here, but there were sanctions in other cases. So this was 11th Circuit case. So now there is this notion of if you're not happy with the decision and you bring a set aside or a vacatur proceeding, but there is no reasonable grounds for such, you may run the risk of being sanctioned by the court.
It's very interesting that the message was very clear on the opinion, right? There was no law before, but kind of now there is. Should I jump on to the confidentiality, or do we have anything else before that?
I think Mauricio wanted to say a few words about the Panama Convention.
Yes, yes. If I may, I asked Tonico and Andrea if I may say something about Panama Convention because it goes a little bit sideways to the topic, but I can hold for if time permitting.
Let me make a comment regarding manifest disregard of law. I saw that U.S. court have this strict and careful interpretation regarding manifest disregard of law to avoid reviewing on the merits by placing a test and a high standard. I saw a case I put on chat. They create a test, high level test, in order to decide if the arbitrator fail to apply the law or the law of the contract. And I thought interesting because I put on chat in a case that I found in a book when I got my master, and it's a high test. One of the case, Superior Court, in Federal Court, they create a test that the court said that manifest disregard to be considered, or for courts to be considered, must be in a record. That record must be indicate clearly that the arbitrator recognized the law and disregarded it in reaching a determination. And give an example. When arbitrator or tribunal refuse to apply the contract and decide inequity, the issue. It's a kind of a ground it's admissible to recognize, but it's very difficult. It's not because arbitrator misunderstood the law that manifest disregard can be accepted. It's a narrow and strict ground, and I thought very interesting because in Brazil we don't have this ground, and courts in Brazil normally are concerned not to review the merits. Besides 8 grounds that we have in Brazilian Arbitration Act, but there is nothing compared to manifest disregard of law. It's for us, it's very interesting, and people in Brazil think that manifest disregard of law can be applied easily in US, but it's not true. It's very difficult. Courts recognize this ground, and this is very important for us because some arbitrators or even judges said, but in US it's possible to recognize manifest disregard of law. It's not easy. That's my comment. And just to make some comparison regarding Brazil. Now, Mauricio, I think you can go to the Panama Convention. Why not?
Okay, thank you, Andrea. Just a side note, Andrea, in another difference. It is not uncommon. I'm not saying it is common, but it's not uncommon to have an award. This is a different topic, but just to shed light on the difference between Brazilian court system and also the US court system, or the Brazilian practice and US practice, and so on and so forth. The notion of reasoned and unreasoned award. So in Brazil, you say, well, there is no way you have an award without reasons. It goes against the Brazilian Constitution, so on and so forth. Here, if the parties so agree, if the award is without reasons, so be it.
Well, that's
but
the
if
standard.
you agree in Brazil also, if you agree on arbitration agreement, courts will don't decide about it. If you decide no reason, but can normally one of the parts will go to the courts to try to set aside, but normally if you assign this contract, it's difficult in Brazil. We set aside this award, and in Brazil, especially in São Paulo, we we don't have this problem, and we never had this problem. We enforce our domestic award in a 95% of our cases. It's
Okay.
difficult to set aside in São Paulo.
There's a historical piece about this because I think the Federal Arbitration Act grew out of cases where the parties had a very high likelihood of respecting the award and didn't need to go to court. So the reasoning wasn't all that important at that time. And from that came the American Arbitration Association, which was founded not too long after the FAA was adopted. And their default on domestic cases, domestic commercial cases, has been no reasoning, but that is really changing. And my prediction is within 5 years, the rules will be changed to require at least what we like to call reasoned light, which means an outline of your reasons enough that people understand the rationale. And but not necessarily with as much reasoning as a court judgment, for instance. And I think that's very important because the parties, particularly the losing party, need to understand why to get a sense of justice. Because even a losing party can feel that they were heard and that they had a fair opportunity if they see the reasoning behind it. No reasoning and they don't have that chance. So I'm really hoping that within 5 years, it'll be mandatory even on consumer cases. And that might be part of the reason there's such hostility toward consumer cases in the US too, is people get these decisions. I order respondent to pay claimant $500. Well, no reasoning at all. I can see why people are upset about it. Or even worse, I find for the respondent, then sorry, claimant consumer, you're not getting anything out of this. And they feel like the system is rigged, and they write their congressman, and there's now legislation. This is just how it works here. You get a congressman who takes up this cause. I mean, I've seen this in real time, and I know who some of the congressmen are who are backing the restrictions on arbitration agreements. And, they're very consumerist, very little guy oriented, but they're going to throw the baby out with the bathwater if they ban consumer arbitration.
Right. And in my experience, Steve, even in those cases, my experience as arbitrator in domestic case here, where there is the arbitral institution rules call or allow an award without reason. So on the procedure order number 1, I always bring this to the parties, and eventually it is agreed to have a reason award. So because of the reasons you've just mentioned.
Yeah, and on the comparison side, I think that in Brazil, in contrast to the US, we have on our arbitration law, right, on Article 26, that we have to have a reasoned award, and that's also grounds for annulment afterwards. So I don't know how the discussion is right now as to whether the parties can depart from that article's application, but given that the US doesn't have that statutory provision, it would be, I think it's a different comparison here from what they would apply in the US as compared to Brazil.
Right. I think there was
AAA is very sensitive. AAA is very sensitive to the legislative process these days. Yeah. They've made a number of changes to try to avoid the issues that are being raised in the legislature, and we'll see. Maybe it'll change.
Yeah.
Okay.
Very briefly, the Panama Convention, and this is as we say in Portuguese, there is a saying: Panama Convention is sort of the poor cousin of international arbitration conventions. But since there is this, specifically in Brazil, this notion of empty clauses vis-a-vis or as opposed to full arbitration clauses, I would like to raise the importance of Panama Convention. And the reason being is that under the FAA, again, Chapter 1, the FAA itself, Chapter 2, New York Convention, and Chapter 3, Panama Convention. So Panama Convention is within the body of the FAA. And Section 305 of the Chapter 3 of the FAA deals with a conflict of convention. When there is a conflict of convention between the New York Convention and Panama Convention prevails. I'm not going to comment a specific case or issue regarding conflict of those conventions other than to highlight the importance of Panama Convention for the United States. And Panama Convention is also law in Brazil, in all Organization of American States except Canada. And I was counsel in a particular case between a U.S. company and a Brazilian company, very sophisticated, extremely sophisticated companies. And the clause of this construction agreement contained one specific clause, which is clause 20.1, the governing law. The governing law says, I'm not going to read it, but it says Brazilian law applies. The governing law, the governing law on the merits of the case. And then there was the arbitration clause, the 20.2. It says the arbitration shall be finally settled by, the case shall be finally settled by arbitration in Panama, X and Y. That is very interesting. You see how sophisticated parties make a mess in arbitration agreement. They say X and Y shall each appoint an arbitrator, and those two shall appoint a third arbitrator who will be the sole arbitrator for the proceedings. But the important point here is the laws of Brazil shall apply. So we have an arbitration clause saying the laws of Brazil shall apply, and we have a governing clause, a clause saying the governing law is Brazilian law. So I have those two clauses mentioned in Brazilian law. Nothing else, no arbitral institution, nothing else, typical empty clause. With that problem of the seat of arbitration being in Panama, but the laws of Brazil being the applicable law. Then the conflict arises, one of the parties files an arbitration in Panama, and under Panama law, the party based this request for arbitration based on the applicable the institutional arbitration rules of the Panama Chamber of Commerce. The Brazilian party said, no, this is a no, because the procedural law, although the seat is in Panama, the procedural law is Brazilian law. Since there is no arbitral institution, the only way to start this arbitration is through Article 6 and 7 of the Brazilian Arbitration Act. So that was the problem. The problem, and the parties were discussing about this. Then there is one single light, which is the Panama Convention. And the Panama Convention, there is one specific provision of the Panama Convention. Article 3 says, in absence of express agreement between the parties, the arbitration shall be conducted in accordance of the rules of procedure of the IAC, which is the Inter-American Commercial Arbitration Commission. And the IAC rules are based on the UNCITRAL arbitration rules. So there you have everything you need in order to start the arbitration. And Panama Convention is a law in Brazil, is a law in the United States, and it's a law in Panama. Eventually, that arbitration was, so we were able to start the arbitration based on Panama Convention, and it went well. And then before the award the parties settle. That was my side comment regarding Panama Convention.
Very interesting.
Interesting. Yes.
So nice.
Okay, a couple of quick words about confidentiality, and then maybe we can open up the floor.
Of course.
So, Felipe, that's your topic.
Yes. All right. I'll try to be brief. So we're talking about confidentiality in the confirmation or vacatur process. So if I'm not mistaken, there is a big discussion right now regarding confidentiality when it goes to the courts. Andrea asked us to address this issue. From what if I'm not mistaken, the last panelists from last month, Federico and Yuri, they explained that in the UK, for example, there is some kind of implied obligation for confidentiality in arbitration hearings. Here in the United States, there is no such obligation of confidentiality, either express or implied. The forum, the courts in the US are a public forum. They're open to everybody, and there's a very strong presumption that judicial proceedings remain open to the public and to the press. So it's very difficult to actually seal a case here in the United States based on this strong presumption for public proceedings and for for parties to be able to inspect the courts and the proceedings. Steve gave us a number here of 0.14% of the cases in 2006 for the 94 district courts of the United States were sealed. So it's much less than 1% of the cases. There are some general exceptions. There are some cases that are sealed, sometimes criminal cases committed by juveniles, some specific matters that might be sealed for a period of time. But that's not very common. There are rules, and this goes to judicial administration rules. So there's different standards on each state and on the different court systems to whether or not to seal a case and what the standards are in order for you to request that case to be sealed. So normally we're looking at local rules of the court that are established by the judges in a particular district. So it varies from state to state. Here in Florida specifically, there are Florida Rules of Judicial Administration, 2420 Section E1. It provides for a motion to seal court records, but it's very rarely granted. The courts are allowed to seal records only when are cogent reasons to do so. This was held in a case from the Florida Supreme Court, Barron v. Florida Freedom Newspaper. And in that case, the court held that courts, when deciding whether or not to seal a file or a specific case or any part of the case, they must balance the rights and interests of the parties with those of the public and the press. And in that case specifically, the Supreme Court of Florida set out a few standards or a few situations in which a court is allowed to place a seal on the case, so to make it confidential. That would be to comply with established public policies set forth in the Constitution, statutes, rules, or case law. Second, to protect trade secrets. Third, to protect a compelling government interest. Fourth, to obtain evidence to properly determine legal issues in a case. Fifth, to avoid substantial injury to innocent third parties. And finally, avoid substantial injury to a party by disclosure of matters protected by a common law or privacy right, not generally inherent to the specific type of civil proceeding sought to be closed. So there's very specific standards. It is a very high bar in order for you to get case sealed. So in general, in case of arbitration, if you're taking it to the courts, normally the parties may ask for the court to seal at least the award or some other sensitive materials. And then the judge is going to obviously consider and balance all these standards to the specific case, and eventually seal some part of the case or not. Of course, the fact that some information might become publicly available is also used by lawyers and by parties trying to negotiate settlements before they actually go into court. So if there's a strong presumption that information may be public and you don't want that information to be public, that of course is an incentive for parties to settle and not actually go to vacatur or some kind of enforcement process. And also, this is something that Steve noted, that it's important for arbitrators to keep in mind when they write the award, not to put too many confidential information on the actual award, because that normally is going to have to be filed with the court. So if you have only, what's very necessary for you to reason your award in terms of confidential information, you should refrain from putting anything there, that might become public and the parties wouldn't want it, since there is a risk that your award will be taken to court. So it's also a way to try to make this lack of confidentiality, I'd say, less damaging to the parties. Steve and Mauricio, I don't know if you guys want to.
Did you mention leverage that people are using?
Yes.
You did mention that? Okay. Sorry.
Yeah, so that's what I was saying, right? So people, when they're negotiating settlements, they'll of course use this as leverage.
They will try to pay less than the full value of the award before the confirmation proceeding, pointing out to the other side that if you force us into a proceeding, your secrets will be revealed.
Yeah, exactly.
Yeah, I remember on this issue, I remember many years ago, there was a highly debated case in Brazil that came out from Texas, and I got access to the court decision on a motion to confirm the award, and also the award itself. It became public. And I wrote an article, a short article. That time we had in our office what we used to call Miami Arbitration Report. So I didn't publish in a sense that this MAR didn't go to any arbitration journal, but I just sent over to some contacts of mine. And one day, right after that, I received a phone call from a lawyer from one of the parties saying, you have to destroy everything you have because this case was sealed. So there was an application to seal after the case has become public. It was interesting, but in order to avoid any sort of discussion or any sort of controversy or any sort of a litigation with counsel, I destroyed everything. But the article had already circulated, so.
Put the cat back in the bag.
Yeah. Yeah.
Okay. Well, okay. Does anyone have any questions? We've had an active chat stream going here, and maybe there's some more questions that would be better suited for asking them orally. All right.
Just hand your hand.
Yep.
I think Pedro had a question, but I think Steve
I think I answered it.
So any questions?
But your question, on the other hand, that I, where was that? was that one? Oh, can all states legislate on domestic arbitration beyond the Federal Arbitration Act? I'm not sure I fully understand the question, but
You
each
answered
state-
it during your presentation. You
oh,
said
okay,
most of states apply FAA, but some
Right.
of them not in all
Right.
entire concept regarding grounds.
They can
And
all
then
legislate.
I got it and that information.
Yeah.
And for me, it's okay.
Yeah,
But
in Florida, for
regarding-
example, sorry, Andrea, in Florida, for example, there is the International Arbitration Act, which follows the ancestral model law.
Mhm. You said before that, for example, New York does not have this manifest disregard of law as a ground. I
in state law.
I thought interesting because it's difficult for us because we have one civil law civil procedure code, one Federal Arbitration Act, and for us it's easy to understand this mechanism. In US, if you choose to work in New York, it's okay. You cannot work easily in Florida or another state. You have to know the law, domestic law, and it's very interesting. And I think it's difficult for lawyers because here you can work in São Paulo, Brasilia, Salvador. Is because we are a civil law country. And regarding confidentiality, we have, especially in São Paulo State Court, we don't have this implied duty to keep confidentiality. But in our civil procedure, in our law, civil procedure law, we have an article that can permit that allows that interpretation to keep confidentiality in arbitration cases. But our constitution said that the rule, the general rule is all cases have to be public. So then judges in São Paulo, including me, we have been broken this confidentiality. We are making some balance between constitutional law and civil law procedure, which where there is that law that can allows confidentiality during arbitration when the issues goes to the arbitration, go to the court. Sometimes arbitrators fighting against this rule, but for us, especially in São Paulo, we consider that this kind of democratic principles, all cases and go to the court has to be public, because decision from judiciary has to be public, because people can control us better, control judges better. There is the policy here in São Paulo.
What if Coca-Cola? What if Coca-Cola had an arbitration about its secret formula?
Okay, we have exceptional cases. For example, patent. How can I say copyright or technology, and there has to be justified the necessity of the confidentiality. And in that case, for example, we normally don't break the confidentiality. we keep confidentiality because there is a justified matter, because transfer of the technology is one of the subject that we normally keep confidentiality. Also, patent. How can I say? Sometimes escape English in my mind, but it is some issues or some matters, as you said, we can keep the confidentiality in São Paulo, but not in general.
I think
Has to be justified.
Fortunately, the rules often provide for some level of confidentiality. So unless the public openness is mandatory law, unwaivable, then the rules will provide confidentiality for the parties.
Yeah. So, any questions?
Yeah, I raised my hand here. Hi, well,
Yes.
Stephen, Mauricio, and Felipe. Thank you so much. That was really very good. It was an excellent debate, and I just have two comments here. One is something like of a counterpoint to what Andrea said about confidentiality. Our Civil Procedure Code of 2015, in my opinion, was very pro-arbitration in terms of including several provisions in the Civil Procedure Code to protect the parties' agreement, especially with regard to confidentiality. And so there is a specific rule that, as Andrea said, judges need to disregard in order to make those cases public. That provides that if there is a confidentiality agreement in the arbitration agreement, that will be upheld in court as well. And so that's an express situation of sealed records under our procedural law, and that is the rule that some judges are disregarding in order, based on the Constitution, as Andrea said, or based on at least on one interpretation of the Constitution, to open those cases. And but what I was going to comment also is on something that Andrea said on chat when she was commenting on a case on manifest disregard of the law. She said at the end, she used the example of a decision that that disregarded the law and applied equity instead. And that is an issue that sometimes comes up in Brazil. We have obviously a difference between arbitration in law and in equity, or like ex aequo and bono, and sometimes parties try to vacate awards, alleging that the arbitrators disregarded the parties' agreement when they disregarded the law and gave a decision based on their notion of fairness. And so I think one of the great importances of having this discussion, and in a way showing that manifest disregard of the law is a very limited notion, and very rarely, if at all, applied. That's very important for us not to understand this type of doctrine as something that will legitimize this idea that by not applying what a court thinks is the law, an arbitrator would be deciding inequity or deciding against the parties' agreement. So I think it's very important for courts in Brazil to be aware that they cannot rely on this vague idea of manifest disregard of the law to legitimize that type of interpretation. And so again, it's a great opportunity for us to be able to hear the three of you and have a very a much more in-depth notion of these things. It's, as we say in Brazil, you know, how do you translate that? You hear the rooster sing, whatever it does. Yeah. And you don't know where, and that basically means you just hear this notion, this vague notion, and then you start applying it. Okay, manifest disregard of the law is my trump card for everything now. And so it's very good that to have this clarification.
That's really good. Is that manifest disregard of the law is a crowing rooster. I like that.
All right.
And to Cesar's point regarding confidentiality, something that worries me a little bit when courts in Brazil, for example, kind of go against the confidentiality rule on the Code of Civil Procedure. And what I think it's a difference to here is that the question of predictability, because here we have very defined standards that are set by precedent by the Supreme Court of Florida, for example, to when a judge can actually seal or not a case. And sometimes I feel that in Brazil, in the different courts, in the different states, the standards vary a lot. But, and then to what Andrea said, you know, in Brazil, we kind of can work everywhere, but we have different visions. And they are not as clear cut as they're normally here in the U.S., where you have standards that are set and that lower courts have to adhere to them. So I think that we kind of lose a little bit in predictability, even though the U.S. is a common law system and Brazil is a civil law system. So we should have a more predictable system. And what in fact we have, since judges are not bound by precedents in most of the cases, we end up having less predictability, and we have courts acting differently regarding confidentiality matters. So I think this is something that we should work towards getting it more standardized between courts, especially.
And predictability is an argument for the federal courts, not the state courts in the U.S., because they all take their marching orders from the U.S. Supreme Court. So I think things do tend to be more predictable there, even though within the different circuits, if there are circuit splits, well, you may know what the story is in your particular circuit, but it's not going to be a countrywide predictable. It's predictable because you can determine, but I mean, what it is in your circuit.
Inside each jurisdiction, you have the Supreme Courts and you have the district court or circuit courts, depending on the that they kind of set standards that are followed by lower courts. Mm-hmm. It may be only on that specific state or that specific region of the circuit. But in Brazil, since it is one system, but it's also very different. And that's just my perspective, and what I feel is we get very different decisions and opinions regarding confidentiality and other matters from judges in Brazil, and there's not much standard as to the reasons when you get, for example, confidentiality break or something like that.
But I think São Paulo, we are very predictable because in the first level, we are specialized, and the judge decides the same way, including issues regarding set aside. When it goes to the Court of the Appeal, sometimes can be different, but even in São Paulo, you can predict how my tribunal you decide about confidentiality. I don't know about another state, but in São Paulo, it's predictable.
Yeah, but that's exactly where the point I'm making is. In the US, we know there are 50 different systems and 50 different states, and that each has their own standards. In Brazil, we're supposed to have one single system, and we have a lot of difference between lower courts. And I haven't been practicing in São Paulo, but I mean, if you have decisions from the lower courts that are reversed by the appeal court, you know,
It's
you have a little bit
sometimes
of,
it's a kind of mess.
yes, you have a little
Sometimes it's
bit of
not
unpredictability.
So
yeah, but just to add on that point, I am a practitioner here in São Paulo, and I agree with Andrea. That courts, the arbitration courts in São Paulo are really quite predictable, because they already have a volume of cases that allows for this type of analysis. And so
Do you feel the same way in Paraná, Cesar? Do
No.
you feel no,
No,
right?
no, not at all.
That's
Not at
what
all.
I'm saying.
Yeah. I think I don't know if anybody from the group here practices in Rio and could maybe give some inputs about Rio, but I think São Paulo is the only place in Brazil where where we can find that type of predictability, because the volume, the number of cases is significant, and judges repeatedly decide the same issues. If this issue of confidentiality, for instance, I believe Andrea and the other judges decide that as a gateway issue in every case, whether they're going to keep confidentiality or not. And so they have their standard thinking about that. Cases go to the Court of Appeals, and it works pretty much as a kind of precedent system, and you already know how some judges think and how some of the panels in the Court of Appeals think. And so I think that adds to the predictability. That adds to the reliability, in a way, of São Paulo as a seat also, because you can know what courts in São Paulo think about several issues in arbitration.
So
and although I don't agree specifically with what Andrea said about confidentiality, I think there is a good side or an upside of in that. And that is precisely the form that the way we are able to learn about those decisions and to have that predictability. Because if all those cases were sealed, we simply wouldn't know.
Yeah.
There is one question that Cesar has placed in the chat. What about manifest disregard of procedural law? I was thinking about that, and I was also thinking, Cesar, about the something along those iura novit curia principles. Let's assume the parties, they are in an arbitration and they placed legal grounds based on what they think their claims are all about. And the arbitrator decides to rule that particular case based on a different legal ground, not raised by any of the parties. So that would probably go into the manifest disregard of procedural law, because the arbitrator didn't allow the parties to brief on anything that, according to him, would be a basis to rule that particular case.
Can I rebut?
Sure.
Sure.
I would say, why build your case around a claim that has such high odds against it, and instead build your case around arbitrator misconduct and bias. Bias because you helped a party with a claim that they didn't even raise themselves, and misconduct for similar reasons, and because you didn't take feedback from the parties when you consider, if you considered it and then you at least asked for feedback, you're in a lot better place than if you don't.
Yeah, point taken. But I was just trying to see, trying to imagine a scenario raised by Cesar, where you did not give the parties an opportunity to present their case, or at least. So that's why I was trying to see if there is any link.
So that's also exceeded powers, because the powers derive from the rules selected from the parties. No, the rules selected by the parties circumscribe the powers of the arbitrator, and if the rules are violated, and I think that would be a violation of the rules, then exceeding powers.
Procedural rules. You mean?
Yeah. But I just like to clarify the question. I asked it when Stephen was talking about how there is no manifest disregard of the facts or of the evidence, only of the law. And in one way that here in Brazil we have something that we call the special appeal to a higher court that's based on points of law. And one way we try to fit evidence and facts into that is by arguing breach of procedural law, a breach of how the court should address or address the evidence, or allow party, or how evidence should be produced and things like that. And so that's why I asked that question. But I think it makes a lot of sense for manifest disregard of the law to be limited to substantive issues, because that's really, if there is any reason for that to exist, it has to be that, right? An egregious violation of what's substantive in law, and not procedural rules that can be addressed by due process discussions and things like that.
I'm wondering to what extent you and your group are concerned about cases seated in the US because of the manifest disregard doctrine, and how I look at that when I know that in the UK it's actually part of their law. I feel a little bit like we're surprised that the US might have this manifest disregard thing, but we're not surprised that it's actually enshrined in the English Arbitration Act.
Yeah, and in other jurisdictions, you have appeal against arbitral awards, and so there. I think we are very mindful of and protective in a way of arbitration in Brazil. Of course, it's only 20 some odd years old, and so it still needs some protection. But I think it's not something that's so uncommon to have that type of discussion. But in the positive side of that in the US and in the UK is that those situations are very rarely recognized, right? And so it's not something that applies all the time and that you can get easily. And I think our fear here, if we went in that path, would be that courts would be much more willing to apply that type of doctrine or of that type of provision than in the US or in the UK. And so I think we have built. And that makes a lot of sense, right? You build your law on your culture and based on your needs. And I think our need is to have everything that we have here: very strict competence, very strict level of judicial review of awards. And I think we're building something that's working, basically because we were aware of what we should avoid when we started.
That's a good point.
Okay, guys, I think we are running our time. I'm so glad to receive this lecture. Thank you again, Steve, Mauricio, and Felipe.
My pleasure.
And I would like to invite our chairman, our president of CIR Brazil branch, to closing remarks. Please, Cesar, you have the floor.
Thank you, Andrea. Well, I'd like to thank Stephen, Mauricio, and Felipe again for this wonderful session that we had, for making the time to be with us and sharing all their knowledge about the U.S. system, and as I have already mentioned, clarifying some very important issues. I'd like also to commend Andrea's and Tonico's work in this specific arbitration in court subgroup of our branch. It is by far the most active group that we have, and today's session is a good indication of the high bar that they have set for speakers and for participants in this group, and it's wonderful that we can in a way offer that to our members in Brazil, the opportunity for this type of discussion. And I'd like to publicly here make an invitation to Stephen. Stephen, we're going to have in October the 20th, a program in the São Paulo Arbitration Week, and it's going to be based on Andrea's and Tonico's work in this group. And so we will have some of the speakers that have been coming to these sessions, and I'd like to invite you to be one of them. It's going to be around this time. I think it's 6:30 p.m. on October the 20th. I'll send you an email properly with a proper invitation, but just wanted to take the opportunity to invite you personally.
Thank you very much. Well, the first thing I want to say is I hope I get back to you faster than I got back to Andrea. I'm flagellating myself for being so remiss, but I would love to do that. I'm looking at October 20th. It looks like a day I have free, so I should be able to do that. That would be lovely. It's wonderful to see you and Andrea again, and Mauricio, a face from the past, wherever that was. Nice to see you again, and Felipe, to meet you as well.
Well, thank you so much. And Mauricio and Felipe, if you want to make any comments.
Or just thank again for the opportunity, and nice meeting you, Steve. Thank you for your help as well, and it was great.
Okay, well,
No
so thank you
further
all again.
comments. I thank you, just that. Thank you, guys. Wonderful,
Thank you
wonderful
all very
initiative.
much. Actually,
Good.
I love the idea of this group, and I'm going to pass it on to the New York branch, because I think we ought to be doing something like it. So what they're probably going to do is say to me, run with it. So the next thing you know, I'll have to do it. So Andrea, I'll be coming to you for the tips on how to get it up and running.
Please.
All right, that's good.
Okay.
Okay. So
Good to
thank
see
you
you all.
again, and I hope, and Stephen, you're more than welcome to join our discussions. This group meets every month, and we'll be very happy to have you with us in
Is
other
it in English?
opportunities.
Is it?
Sometimes it is, not always.
But you know, I was actually thinking of asking about that. I think I'd really like it, and if they're in Portuguese, then I'll just drop out. But
okay,
that sounds
yeah,
like fun.
we'll let you know. We'll let you know, especially when it's in English. And,
okay, well, perfect. Sure.
Okay, and if you're not there, if you're not yet, I will put you on our mailing list as well, so you will get the information from the branch.
Great. That sounds really great. Thank you very much.
Well, thank you you all, and